Yeah, he muted himself because
Okay.
besides putting you on, he's also at the Bronx family DD Council.
Oh, I understand. Sorry. Okay.
Okay, guys, because at the same time I had to mute because I have to set up the recording. Now I'm trying to, and we're ready. Good morning, everyone. Welcome to the Family and Provider Information Committee. Since today is November month, the day before Election Day, today's November 9th, so I hope everyone's doing well. Before we introduce our co-chairs and our speaker, we do need to remind everyone with the housekeeping rules. Right now, every microphone should be unmuted. Too many microphones will automatically mute everyone, and it's called a mic jam. Please, everyone, as our speaker is speaking today, please hold on to your questions until she's completely finished. We're going to remind you all to please let her finish her questions. She'll give you the antidotes, the medicine, and all the good stuff. As to remind you, there is a new button. It looks like a smiley face on your panel. That is to raise your hand and has other devices in there as well. The chat box is still available, as well as your other devices, your microphone and camera. So please make sure you use those. If you have your camera on, you can keep it on or off, but microphones must be muted when the speaker is speaking at this time. As also remind to everyone, this meeting is recorded and it's duly transcript, so every word is still copied, and make sure that any notes we need, we have it duly noted into the meeting. So please make sure we follow the housekeeping rules at the same time, and we will proceed now to introduce. First, let's welcome Rosal and Deborah Bright. They can just say good morning.
Good morning, everyone. I'm Rosal, and I am the chair of the Family Provider Information Committee, along with my co-chair, Deborah Bright.
Deborah, you're muted, and you're double clicking. We can't hear you. You're still muted. You're still muted. We don't have control of that. That's you. We can't. Can you please touch the mouse to the microphone? There you go. Say hello.
I can. I'm muted.
Nice
Hello.
try.
We can hear you now.
Oh, good. I can hear me now. I don't know how. Good morning again. My name is Deborah Greif. I am the parent co-chair of this committee. We welcome everybody. We're very glad that you are here. We appreciate everybody's participation. It's only thing I'm going to say is the parent co-chair. It is very important that our agencies please understand different services that are being offered by OPWDD through their umbrella agencies. That means, and it's very important, about guardianship. But I'm going to let my co-chair, Ms. Rosal, introduce our speaker.
Thank you, Debbie. Good morning again, everyone. And I would like to introduce our wonderful speaker who's been here with us numerous times to provide us with, very insightful information on guardianship. Her name is Paola Martinez-Bone, and she's a senior advocate. Welcome, Paola. We are happy to have you.
Thank you. So I'm ready to start, Chris? Yes. Oh, no. Okay.
It's all yours, Paola. Just click on the share. Paola, you can share your screen. That's right next to the thing, and it will take you right to your PowerPoint.
Okay.
And as Paola's getting on, good morning, everyone. And I'm reminding everyone as you're coming in, please mute yourself as Paola is now up to her presentation as she's loading right now. We ask to remind you, everyone, to please keep your microphones muted. And as you guys came in late, please, if you have an announcements or anything, please put that in the chat at the same time. Paola will be starting in just a second. Thank you.
Give me 1 second. I'm trying to upload my presentation.
That's fine. That's fine.
Oh, where did it go? Can you guys see the presentation? No? Yes?
No, Paola, we're seeing
No.
your email.
Oh, okay. Oh, what's going on here?
It looks like future plan. Is that your link?
Yeah, that's the link to the
Yeah,
presentation.
you need to open that link. If you can
Yes,
open it.
please.
Let me see. Now I'm stuck here. Escape. Okay.
It looks like it's in your email, Paula. If you want, do you want to forward it to Chris or myself, and then we'll see if we could share it on our end?
Rose,
Yeah.
can she share it to you?
I could see if I could share it on my end. Yeah.
Okay, so yeah, I just email it to me because I have it download, but it's not opening.
Okay, so Paola, once
I
you send it
send
to
it
Rose,
to Rose. Yeah, I send it to Rose. I just send it.
okay. Rose, since you're dealing with that, let's give Deborah and you guys like a few minutes doing your report for during next month's meeting, so we can then hold that so when Paola's ready, you can get it back on her. Did
No
you get what I said?
problem. Yeah, I
So
heard.
Okay,
I'm here.
so let's do Deborah's report. Let's do the co-chair's report. So it gives you guys a chance to do the PowerPoint.
Okay. Good morning, everyone. I have a few things to report, but I'm going to keep it short and concise. I have been I attended all 5 District 75 transition fairs in each of the 5 boroughs. And this past Saturday, we also went to one of the D75 schools that's right behind in Queens, the Queens Mall. One thing I've seen is that parents are eager and want to get services from OPWDD, and some of them understand what they have to do, but some don't. So we were there more. Now, I just want everyone to know that we were there. I was with Christopher's because the schools have asked us to help families sign up for their children's Metro card reduced fare, as well as if they're going to switch to the Omni half fare soon. So that was our position. But when the families asked us questions, we also made them understand how important it is for them to have their child has their own reduced fare Metro card, because due to the child's developmental disabilities, they qualify. So they were very happy to hear us. So what I'd appreciate from every agency that shows up today, please let your families and your agencies know how important it is to have the reduced fare Metro card for their own child. Because even though say, oh, my child doesn't travel alone, but I said, but you take your child places on through many times the bus, train, or even Accessor, and they said, well, yes. Then I said they should have also their own reduced fare Metro card, as long as they're over age 7, 8. But it's very important. So then it's like a light bulb went up, and they went, oh, you're right. So that's why we were there in all the schools, because it's very important. Not every family understands us, and we were glad to help, because when they turn 21 and the New York City Department of Ed's buses stop coming, the children still need to have their own Metro card or eventually their own Omni card. So we were very happy to be successful to help those families. Yes, we're
And
hearing.
also, just sorry to interrupt, but we will show that information later on. I will have
Yes,
that in my report. But at the
yes.
meantime, is the main
I
thing is
see.
everyone. I will continue. We will continue talking about that later because the
Yep.
focus is there are some a lot of things are coming down from Albany. We need to be alert. And Deborah has been mentioned this at the other meetings, but we need to place that everyone once we have these couple of new elected officials, we need to make sure you guys go visit them.
Yes, we also, I did have families. Well, I have to say this, whatever agencies and care coordination agencies, the biggest complaints I'm hearing is about the reimbursement ADM. We said it's a work in progress. I told them in each borough that we're in, you need to contact the local Brooklyn, I'm sorry, not Brooklyn, Developmental Disability Regional Office to, if you feel you need more extra training. If you can't get through, you can always go on. I gave them the website for the advisory council for this reason only, was so that they could get to the link on how to check the new reimbursement ADM, as well as we said they're the emails for the the family support coordinators and the reimbursement people who are working with reimbursement through OPWDD. So that's what we did. We asked them, whatever borough they're in, they needed to contact their own local DDRO. So with that, it was very successful. We were very glad to be there to make sure that we were able to get a lot of individuals with their families signed up for their reduced fare metric card, not fair fares, reduced fares, and also to make sure their information was updated. But Chris will go on further. And I see now that Paula's information is online, so now I'm muting. So we'll talk later. Bye.
Yeah, Paula, you can unmute now.
Okay, good morning, everyone. Happy that you're
Morning.
all here. My name is Paola Martinez Boone. My agency is the New York Lawyers for the Public Interest. I'm happy and excited to be here once again, providing this important information. I glance at the participants and I see that it's a lot of people from the agencies, and I'm happy to see that because I get a lot of calls from you, and I welcome those calls. Chris can share my information. It's on the it's right here on the PowerPoint, but it could go in the chat. I always open to answer questions, to answer concerns. So feel free to call me and to email me, and we can set aside time to speak about your particular issue. So New York Lawyers for the Public Interest, real quick, is a nonprofit legal organization. We provide free legal services. We don't charge for any of our services. And under the Disability Justice Program, we represent people with disability, the people that you are serving. They are our clients. And we provide individual representation as well as class. And class means that when we identify a problem that is a systematic problem, and we have calls, clients identifying the same problem in the system, we analyze it, we assess it, and if we have the capacity, we take on in order to improve the systems. If you have any questions regarding our program of services, you can actually go into our website, nyLPI.org, check what we have done in the past and what we're working on right now. And if you have clients that they themselves need the assistance or their families on behalf of one of your clients, they can call us, or they can click here in nyLPL.org, get help. And you don't even need to call us. You can click there. They ask you 3 questions: your name, your telephone number, so we can get in contact with you, and what are you calling us about. If you're calling about an issue, a legal issue that we don't have a practice on, we will always give you a referral. We will not leave you hanging. We will provide you a referral most of the time to another nonprofit. We don't refer to private practitioners. We refer to other nonprofits. I'm not going to spend much time on that. Regarding this presentation, it's free. This PowerPoint I could share with you. I could email it. You can email me asking me for it. I'd be more than happy to share with you. The only thing that I ask you is that if you're going to share it to other people, families, or other professionals, you need to use the same format, and you need to forward in the same way that you receive it. This is intellectual property of New York lawyers for the public interest. So you cannot cut and paste. You cannot just take pieces of it. You have to share it the same way that you receive it. This slide is going to go real quick because this is information about my agency. And if you want to spend time learning about us, go to our website. Okay, so I'm gonna go right into what I'm here today because why planning for the future. So first and foremost, I want everyone to understand that part of the planning is to preserve government benefits, Medicaid, Social Security. And you're gonna understand along the way what I mean by this. If your child is in school right now, a lot of their services that he or she is entitled to are provided by New York City Department of Education. However, adult services, when they age out and they need to move to the OPWDD system, that's a system of eligibility. People need to be eligible for those services, and the payer of those services is Medicaid. So that's why it's important to understand that we need to preserve government benefits. The other piece of planning, families want to improve the quality of life of the person with disabilities. In the past, people with disabilities were not working, so therefore the only source of income were like government benefits. Not anymore. People with disabilities work and receive benefits because there is this movement. There was this movement to improve the quality of life of people with disabilities. The other piece, why do we need to plan? To expand our choices and not to limit. Okay, how do we start? Many of you professionals here know that you know, if you have a life plan, if you have created a life plan for your clients, you're talking about the medical, the behavioral, the social, emotional, the services that they need. That's how we start planning. However, families could plan and add to the life plan and do their own planning. But what I want you to take away from this is that families need to take action. They need to be involved in the planning of that person with disabilities' future. I've been doing this for a long time, and it pains me to hear that many families are afraid to plan, and they tell me, I'm not gonna do anything, I'm just hoping for the best. Don't hope for the best. Please get into action, start planning. And in this era, like I said, you can not only rely on government benefits, you can add to government benefits. And I'm going to tell you how. Many of the families, actually, somebody called me yesterday. As a matter of fact, they have families work, mom and dad work, and they have pension plans, they have life insurance, they have things that they want to eventually leave to the loved one with disabilities. So how do we do this correctly? We need to put those assets in the right place. We cannot leave money straight out to the person with the disability, because what happened with that is we're gonna interfere with the eligibility, and eligibility for public benefits, that is, and I'm gonna talk about how to do that. In the process of planning, and I'm only talking about my piece of planning, I'm not talking in general planning because it's many pieces to it. I'm talking about, this is really what I'm talking about in this workshop about planning, the things that I'm gonna explain today, from the basic letter of intent all the way to guardianship. Okay, letter of intent. So the letter of intent is not a legal document, and I want to be clear about that. It's not a legal document. However, the letter of intent provides a lot of information about the person with disabilities. Many of us go about our day taking care of our loved one with disabilities. However, is our information, and we don't share with anyone. Sometimes I get calls from siblings of the person with the disabilities because mom is in the hospital, dad is in the hospital with the mother taking care of her, and nobody knows what to do with the loved one with disabilities. So what the letter of intent is really a document that you create as a family, in which you're gonna state everything that's going on with the person with disabilities, the programs that they attend, who is the care coordinator, what's the name of the agency, doctors, medications that they take during the day, if they like to do recreational stuff on the weekends, you put that. Anything that you believe that is important, you put it on the letter of intent. Because if something happens to you, and I have a lot of single parents that call me, if something happens to you, who is going to care for your child? And we're not talking about if you die or pass away. We're talking about a day that you get sick, a day that you have surgery, a day that something happens, you be fine today and you have chest pain, you have to be rushed to the hospital. Who is going to care for your child while you're there? And how they're going to know to do it if you don't leave something behind telling them what happens during the day. So that's really the purpose of the letter of intent. It's not a legal document. You don't have to notarize it. You can mail it, email it, test it, share it with as many people as you want. So you will have a village of individuals that know what's going on with your child during the day, their routines, and they will be able to assist you. That's the sole purpose of the letter of intent. Now, because today we're going to learn about decision-making, including guardianship, the first thing that we need to understand is that when we're talking about documents like guardianship or a process like guardianship, we have to understand that is all related to mental capacity. So not everyone with a disability needs a guardian, because even though we have a lot of people with disabilities, they not all lack capacity. So the definition of capacity under the New York State law is that everyone who is 18 years of age is presumed to have decision-making capacity. So if you're dealing with a person who is 18 or older, that person, disability or not, they're presumed to have capacity. That's what the law says. Now, who is an incapacitated person? An incapacitated person is a person who is impaired by reason of mental illness or mental deficiency to the extent that she or he lacks sufficient capacity to manage her or his affairs. A ward is a person for whom a guardian is appointed. The key here is word appointed. We have families, we have mothers, we have fathers, we have uncles, grandma that been taking care for a person with disabilities. When this person turns 18 and they are adult, they have decision-making capacity. You will only become the guardian if you are appointed by the court. As the definition said here, who is the guardian? A person who has been appointed by the court to make decisions on behalf of a minor or an incapacitated person. Surrogate decision maker is any individual who is authorized by law. Once again, we're talking about legal here, authorized by law, or who is in fact making decisions for another. The Family Health Care Decision Act provides a process for a surrogate decision maker to make end-of-life decisions on behalf of someone who lacks capacity. So we have some definitions here. Now, how can we evaluate capacity? That's a question that people ask me all the time. How do I evaluate capacity? Well, you need to explore the decisions that that individual has made or facing. The second one for me is very, very important for families to understand, which is balanced respect for the individual's self-determination and protection of his or her well-being. We need to balance that. We need to respect for those individuals with disabilities who are able and capable to tell you what they want and what the decisions are. You have to be able to respect those decisions and also keeping in mind that you want to protect that person's well-being. So, and this is like tricky for families, because sometimes the individual is telling them one thing and the family is in disagreement. Not because it's harmful, it's because they don't want it. And we have to be very careful about that. We have to encourage people with disabilities to make decisions decisions that, that we explain the consequences. That's the part, right? When we're making decisions, we also have to understand the consequences. But the goal here for those individuals with disabilities who are capable to make decisions, we need to support that, and we need to let them, make those decisions, but also protecting their well-being, making sure that they're doing the right thing. The predetermination of decision-making capacity prior to an event presents serious problems. The ability to give informed consent or to make a contract must be separately determined. So the third one talks about if we're dealing with a person with disabilities, we need to understand their level of capacity in order to make sure that they're able to consent, for example, in medical, to treatment, to sign contracts, and that have to be predetermined. You're not gonna take a loved one, an adult one with disabilities, and then try for them to decide at the moment where they need to sign a document. We don't want to do that. We want to work with that individual and to understand that how they access information. If the information needs to be broken down, if the information needs to be explained in a different environment, so that way they prepare to make those decisions. When we're talking about people with disabilities, we need to understand the level of capacity in order for us to support them, in order for us to work with them. That is very important. What are the areas, the component of decision making? Ability to communicate a choice, and we have to respect that. For example, if we have people with disabilities that like to dress in black, but the family don't like black, we have to respect that decision. So we cannot disregard a person because they have a disability and they want to wear black. And I see it all the time. Like families taking over, I don't like black, but he likes black, so he's gonna wear blue today. Please, we cannot do that. We have to respect decision making. Ability to understand relevant information. When we're talking with people with disabilities, are they able to understand the information? Even if they take them longer, even if it takes us a little bit more work to explain and breaking down that information, it's important for us to see if that person really understands the information. That person's ability to appreciate the nature of the situation and consequences. Like everything else, we need to prompt those questions. Like, okay, if you want, for example, to move independently, do you know what takes? Do you know that then you need to pay rent? Do you know that you need to pay bills? Like what, moving by yourself is a good start, but what is the consequence of that or the benefit? Ability to manipulate information rationally. So all that are components to decision making. So what are the domains? We do this all the time. We make decisions about where we want to live, our social activities, work, training programs, legal action, healthcare, personal routines. So these are the areas in which we constantly making decisions. Okay, so now I'm gonna go to the other piece of planning that have to do with the preservation of public benefits. So I'm gonna start by explaining what is a regular trust. So a regular trust is an instrument in which you will put stocks, bonds, property to benefit somebody else. I'm giving you the short version. The long version is here that you can read on your own. But that's the short version. If you want to open a trust, it's because you have something to leave behind for somebody else. Now in red, I put you who are the players in the trust. Grantor is the person who creates the trust and also put in the money. That's the grantor. Most often, family members, mother, mom, dad, grandma, that is the grantor. Who is the trustee? The manager of the trust. So for example, if grandma is the one who's giving the money, mom could be the trustee. Mom could be the manager of that trust. And who is the beneficiary? The person who is receiving the money, the person who is benefiting from this trust. So this is a regular trust. Now, because we're talking about preserving benefits, then for individuals with disabilities and the elderly, there is a different trust. and it's called supplemental needs trust. So supplemental needs trust is a special type of trust with the purpose to preserve public benefits. With that, this means is that a person could have a supplemental needs trust and still be eligible for public benefits, and that is the purpose here. Two important keys about supplemental needs trust. It's irrevocable, meaning you cannot change it, and it's discretionary, meaning the trustee will have full authority. Trustee is the manager, remember, to refuse or to make distributions. So if you're a parent, you're a family member, and you want to leave money behind for a loved one with disabilities, what you want to do, if you have a life insurance, if you have a pension plan, as a matter of fact, like I said, somebody called me about this yesterday, a parent that want to establish a trust, you must open a supplemental needs trust with the understanding that you cannot change it, it's irrevocable, and it's discretionary, meaning in the beginning, if this is a trust for your child that you want to put together and you are the trustee, you are the manager, you have full authority. However, as you age, as you perhaps get sick and you cannot be the manager anymore, whomever you appoint as the trustee of the manager, that person have full authority to refuse or to make distributions. That is important. Now, under the supplemental needs trust, there are two types of trusts, first party and third party. And I'm gonna explain the difference. The first party is the one that is funded with money or assets of the person with disabilities. Now, a lot of people here ask me, but my child doesn't have any money. Where he or she is gonna get money to fund a trust fund? Think about an inheritance or a lawsuit. As a matter of fact, I get those calls all the time, but unfortunately after the fact. If you are suing someone, if the person with disabilities got injured because of medical malpractice or because an accident, whatever that is, that they're suing someone and they're going to get money, whoever is working with you in that lawsuit, you need to talk to them about establishing a first party trust, because this is what happened. If the lawsuit is settled and the person with disabilities end up, let's say, for $100,000, but that $100,000 is not put into a trust fund, they're not going to be eligible for Medicaid anymore. Eligibility for Medicaid is $14,000 or less. So if you got $100,000 under the name of the person with disabilities because a trust was not created, that person is not going to be eligible for public benefits. So once again, the key here is the preservation of public benefits. If you are suing someone on behalf of your loved one with disabilities, you need to talk to that attorney about first party trust. Okay? Now we have third party trust. And the third party trust is funded with money other than the one from the person with disabilities. So that means parents, grandparents, family members, neighbors, anyone could create a third-party trust to benefit the person with disabilities. The rule is the same, irrevocable and discretionary, meaning once you as a parent, grandparent, friend of the family creates a third-party trust for your loved one with disabilities, once you create, the rules are put in place. It's irrevocable, you cannot change it. And discretionary, meaning whoever is the trustee is the manager of that trust. Now, for the people who are from agencies here, I have to tell you that a lot of parents in the past have assigned an attorney to be the trustee. People who are the trustee who are not family members usually get paid a percentage to be the manager of the trust. What that means is, unfortunately, that is based on the amount of money. Let's say if the trust is $100,000 and they get 1% of $100,000, most likely, if they're not a family member, sometimes they deny a lot of requests. Why? Because the more that they give out from that trust, the less they get as a payment. It's sad, it's unfortunate, but that's how it works for many, many, many trustees. So in the case of family members, usually a non-issue. If it's mom, the trustee, and this is the money that she put for her child, there is no money. They're gonna, release the money. It's their child, and that's why the money is there. But I'm talking to the agencies because sometimes I get those calls that they ask me why the attorney who is the trustee is not releasing or not approving of what we're asking. The reason, I don't know really the reason because I'm not in their head, but because they get paid from the money that is in the trust, then sometimes they don't want to release. Or it could be, not everyone is the same. I'm not going to say that everyone is doing that. Or they could be that whatever you request and they don't think is needed. But anyway, that's one of the reasons. I'm going to skip to the pool trust and I'm going to go straight to a 529A account, which is a wonderful tool also to put money aside for your loved one with disabilities. And the ABLE account allows families and also the individual with disabilities, if they work, to put money aside while still preserving public benefits. So many people in the past thought that they could not save anything if they're a person with disabilities and they're working, but they also have Medicaid because that was going to interfere with eligibility. So the 529 ABLE account, similar to the trust fund, allows people to save money. If you're a family member, you can save money on behalf of your loved one with disabilities. If you're a person with disabilities, you can save money in this account and still be eligible for public benefits. These accounts are run by the New York State Comptrollers, and I have their link and their telephone number at the end of the presentations on the resources. And if you want more information and more detail about how this works, you can go to their website and you can also call them. So if you're interested, that's the way that you can settle an account. Now, the other piece of this is like many parents, when the children were small, they open a college account, a 529 college account, but now they realize that perhaps the child is not going to go to college, so they can transfer actually that money into this account. But once again, the experts in this area are the people who have the program and the people who runs these accounts. And I will suggest to you read about it, go to the website, but also you can call them with questions, but it's a great benefit for individuals with disabilities. Okay, so now we are getting close to talk about guardianship and other decision making. So I want to give you this side to side because guardianship is not all for people with disabilities. Guardianship, as you can tell here, is the most restrictive option. I understand and I'm clear that many people that we serve with IDDD will need guardians, but we have a lot of other people, I could say the majority, that would not need a guardian. So the least restricted option is, of course, the person making his or her own decisions. And that could be with supports, okay? Then we have healthcare proxy, we have power of attorney, we have supported decision-making, and in the most restricted line, we have guardianship, we have surrogate decision-making, and we have the Family Care Decision Act, which refers to the end-of-life decisions, like I explained early on. Okay, healthcare proxy. First, we need to understand that in order to have a healthcare proxy, the individual must have capacity. So if you call me and said to me, my loved one doesn't have capacity, they have a very low IQ, they're nonverbal, but they know how to write their name, I want a healthcare proxy, this is not the document. The individual must have capacity to sign a healthcare proxy. Why is that? Because as an individual, you need to assign a care agent. a person who's going to make decisions when you cannot. That's number one. Number two, this is not for everything and anything. Healthcare proxy takes effect only after two doctors decide that a person no longer has capacity to make decisions. So what this means is the person is making decisions all alone, even when they have a healthcare proxy agent. However, if it comes a time that they're not capable to make those decisions, then two doctors need to agree to that. So we need to take this into account. It's not automatic. Also, when you fill out the healthcare proxy, it have boxes that you check, and then you check also in what areas you will need this assistance. So once again, we need to be careful and understand the person's mental capacity in order to decide what's the best instrument that we can use to support them. Similar to the healthcare proxy, we have a power of attorney, and this is for property, financial, legal decisions. That's why you have a power of attorney. Now, power of attorney have a change in 2020, and now we have two types. One is called springing, in which you will name an agent in advance, just in case that if something happens to me, I already have this tool in place, and this person is going to take over to making my financial decisions when I become incapacitated. So I could write it up in advance, but nothing happened until it's determined that I don't have capacity any longer. And then we have the traditional one, which is the durable power of attorney that becomes effective immediately. Meaning if I go with my agent and I assign my agent and I sign the papers and that takes effect immediately. That means that my agent will have access to all my finances in accordance with what I wrote in this power of attorney. And we have to be careful about power of attorney because once again, our agent that we pick could empty out our bank account. So even though I think that's the minority, if we're assigning someone to be our agent for a power of attorney, we need to be careful who that person is going to be and be specific about what is the purpose of this. Most of the time, I see power of attorney people who have mental health issues, mental illness, major depression, bipolar disorders. So they will have someone appointed just because if they're not feeling well, at least someone will have access to the finances and pay their rent and pay their bills, so they don't fall behind what they are, trying to, take care of whatever situation they're in at the moment. So that's the purpose of power of attorney. So we have another less restrictive, which is supported decision making. Now, supported decision making is it has been in New York State for at least 6 years. It was a pilot program, but it became law last summer, I think March. So now what's going to happen is that supported decision making, different from what I have here, that is not a legal document, now it's going to be a legal document. And this is really amazing because supported decision making will cover those individuals who really don't need a guardian, but they still need support in making decisions. So the process is really a process that lasts months, in which the individuals from supported decision making will, work with the family, understand the needs of the person with disabilities, understand the areas in which that person will need more supports, and draft a document stating all that. But once again, it's going to be a legal document, enforceable. That means it's going to be enforceable. And it really, really applies to a lot of people that guardianship is too severe for them. If you are interested in exploring information about supported decision making, I encourage you to do so. I have links with the videos, and I have the link for the agency that does this process. I've been advised by them that even before you pick up the phone and call them, watch the videos because they are informational videos. I guess what they want to what they're really saying is before you call them, inform yourself about how it is. So when you call them, you spend the time in questions, for them to answer questions, things that you don't understand. So I'm happy to report about, supported decision making to be now law, and it's going to be enforceable because a lot of people with disabilities could benefit from them. The other part that I want you to understand is that judges are going to be informed and educated about supported decision making. So for a lot of people who are going to be applying for guardianship, once they review the documents and they check and they realize that the person that you're applying to become the guardian for is not a good fit for guardianship, they gonna actually advise on support decision making. So that's also another change, that the judges are gonna be experts or in understanding how supported decision making works. And a lot of people who will be applying for guardianship when guardianship is not appropriate, perhaps are going to get information about how to apply for supported decision making. Another one that is restricted is surrogate decision making. Basically, this is if somebody doesn't have anything, doesn't have supported decision making, doesn't have guardianship, and they're adults, and decisions need to be made, especially medical. And then what happens here is that somebody needs to sign the contract. Somebody needs to agree to surgery or to a procedure. So what happens is that the doctors will fill out with the family a request to surrogate decision making, send it, and then they will get an answer 14 days. I'm being told that sometimes it takes shorter than that. But once again, if you don't have your child needs a guardian and you're not the guardian, or your child is eligible for supported decision making and you don't have that, don't panic. Surrogate decision making is another tool. What I'd be cautious here is that don't be waiting for those emergencies in order for you to plan. That's what I'm here today, to encourage you to plan. So, but this is another option out there. I already talked about the Family Healthcare Decision Act. You can read more about it. This is regard to, end of life. So now we're going to talk about guardianship, finally. So a guardian is someone appointed by a court to make decisions on behalf of somebody else. A guardian can be appointed to make financial decisions, known as a guardian of the property, or personal decisions, known as a guardian of the person, or both. For families who are attending and providers, if you have a person with disabilities who doesn't have anything, there is no need of guardian of the property. Social Security is not counted into this. Social Security checks. If you are the payee, you still don't need a guardian of the property. For most people who actually need guardians, it's going to be a guardian of the person. I want to stress this because I got a call 2 weeks ago that somebody applied for guardian of the property. The person doesn't have anything, and the court is asking for receipts. You don't need to get into that. If you apply for the guardian of the person because the person have Medicaid and Social Security, that's all that you need. If that person is going to get money, as I explained earlier, you can open a supplemental needs trust if you are putting money behind, if you're a family member, as I explained, or if this person is going to get money because of a lawsuit, first party trust also. If you want to put money into a savings account for this person, please use 529 ABLE account. So once again, if you have any of those other choices to preserve public benefits, don't get into guardianship of the property because it's not worth it, and you're going to be asked to submit receipts to the court because you did this for no reason other than nobody explained it to you, which was the situation of the person who called me. Okay, so there are different types of guardianships. So the type of guardianship for individuals with intellectual disabilities or developmental disabilities is Article 17A guardianship. This process in New York State, and we are blessed in New York State because you don't need an attorney for this process, is paperwork. Okay? You must go in person to file the petition, and you don't need an appointment, but the forms are available online. You don't even need to go to the court. You can do the forms at home, at your own computer. You can copy and paste from one form to the other. You can, the forms online have a drop-down menu, so sometimes you don't even need to type. So it's easier to do it at home, at your own computer, or at the library, whatever is access to online and computers, you can do it. You don't have to do the whole petition one day. You can do one form today, save it, and then continue other days. In this process, you're allowed to have a guardian or co-guardians, meaning one or two individuals. If you are planning to have two individuals, you have to be in agreement with that person. And nothing happens if both individuals need to sign and it's only one available. And this is important information because there are families in which one of the parents or the family member is always traveling for business and they're not available, but they are co-guardians. So they need to sign documents. Once again, that's the reason why you are a guardian, because you're supposed to take over decision-making. If you're not available, then you cannot be a guardian. Well, I will suggest that person would not be. But the forms also give you space for other people. You can add a standby guardian, first alternative, or second alternative. So you will be the guardian, and the guardian will be the decision maker. However, if the guardian pass or become incapacitated, then the standby guardian, I believe, have 90 days to go into court and say, the guardian is no longer with us, and therefore, and the standby guardian, I need to become a guardian. And they will not have to fill out some paperwork, and they will take over as guardians. So that is really, really important. Also important, because you apply for guardianship doesn't mean that you're going to get it. If the judge decides that the person with disabilities have enough capacity to maintain decision-making, even though with supports, they're going to deny the guardianship. And that is also, a lot of people are surprised by that. Don't be surprised if the judge says, I'm denying the guardianship, it's because they read the documentation, included affidavits from doctors saying that this person perhaps have a level of capacity. So we need to keep that in mind. There's also another type of guardianship, this Article 81. This guardianship can also be used for individuals with IDDD. However, this court process requires an attorney and requires an evaluator. So in order for you to tailor a guardianship for your loved one with disabilities by using Article 81, you need to have enough money for all those fees. This is a very expensive process. This is what, if you're familiar with Britney Spears, this is what Britney Spears used to have. So, requires an attorney, but I have to provide the information to you. If you're a person who has means, or you're working with family who have means, and they want to do this type of guardianship because it's tailored, it's no take it all like Article 17A, they could do that as well if they see that this fits. Okay, what are the reasons to pursue guardianship? Well, without a guardian, many of the individuals may not receive the appropriate services. And I'm clear and honest that I know a lot of individuals that I serve will need guardians. However, I also aware that there are other group of individuals with disabilities that would not need guardians. And a reason to avoid guardianship is because it's an intrusion of the personal autonomy. Like I said in the beginning, we want individuals with disabilities to be independent and to have a voice. If guardianship is not appropriate, we cannot force it on them. And there are, other reasons why the court intrudes into the life of the person and the life of the guardian. If you don't know this, everyone who applies for guardianship gets fingerprinted. So, and they ask you for your address, your telephone number. So the court really gets into who is going to be this guardian. And once again, if there are other alternatives who are a better choice for your loved one with disabilities, we must consider those. But I'm also aware that many people will need guardians. Okay, so in terms of where do we submit the paperwork, you have to submit the paperwork in the location in which the person with disability lived. If the person lives in the Bronx, you will submit in the Bronx. If the person lives in Staten Island, you will go to Staten Island. So you need to be aware of that. Those links are actually direct links to the forms as well. If you get this PowerPoint, you will have the direct links right there. And my last slides are all resources for you. Everything that I talk about here, there are links to it. I hope that Chris put my email and my contact information. If you have families who are not clear and families who need resources and need information, I'd be more than happy to talk to those families. Everyone who knows me that I'm doing this for a long time, I'm very, very good at responding to families. Sometimes they need 30 minutes. I arrange an appointment time and I'll give them 30 minutes. And if I have the time, even more. So this is it for me. Thank you so much. If you have questions, this is the time to ask me.
Thank you.
Hello, Paola. It's Debbie.
Hi, Debbie.
Yes, hi. As co-chair, I'm taking, first of all, I love the presentation, except I didn't see all the slides, but that's okay. I'm very glad you brought up about the benefit problem because, one, I'm going to talk first only as a parent. I've been attacked for not going for guardianship, as we all know, Chris. I've also been attacked because I didn't do certain other things. My son, when my mother was alive and he was he was a minor and a single parent, I had my mother as his surrogate guardian because I had to have surgery twice.
Mm-hmm.
And I said I wanted him protected. Of course, people give me a hard time, but the biggest part they're giving me the hardest time, and I appreciate something you're saying. My son, I have not held Christopher back. It's what he wants to do. But when we tried to work, because OPWD, they used to say the employment training program was a stipend when it was a wage. I'm not the only parent across New York State went through that, but I made a major scream, so that was fixed. But they don't understand that even if you report it correctly, SSI, Social Security, can take your the 1 month you have money, but next month you don't. And they look at me like, oh, you don't know what you're doing. Well, I do know what I'm doing, and I've seen what happens. So what do you say to these people who don't want to back off you? And your child who's made his own independent decisions. Okay?
Mm-hmm.
Okay. So go ahead. I need help me.
I'm sorry, David, you have a question?
Yeah, the
Because
question is, how do I get these people, professionals, and who tell me I don't know what I'm talking about? The question is, what do I do to get these people off our backs? Because I'm protecting Christopher, and I'm going by independent. What you said about if an individual is capable of making decisions, but how do I get these people off our backs? It stresses me. That's why I'm asking you, what do I do? Get them to stop.
Got it. So Debbie, first and foremost, I have to give kudos to Debbie because Debbie is one of the most active parents that I have ever known in my life doing this work. A lot of individuals who are professionals sometimes are still misinformed about how the systems work. So, and I actually, the only reason why I continue doing this work, and I be honest here, work is not funded. My agency doesn't have a streaming fund to provide this work, but I continue doing it because I want families to be informed and I want professionals to be informed. And unfortunately, I wish I could say something, Debbie, and tell people, please stop bothering Debbie. She knows what she's doing. But because also our system is a system of a revolving door, we're always getting new people who may have titles, but sometimes they don't know about certain topics such as Social Security, such as Medicaid, such as what I talk about, guardianship, other choices. And I will say sometimes it's not even their fault because you don't know what you don't know. So I will say the professionals in this room, we also have to acknowledge and identify the areas in which we don't have experience. And we have to reach out to those people who do the work before we get on a parent, before we get on a family member, before we give information out. I have to say, I'm doing this, and Debbie knows this, know me for a long time, for over 20 years.
It's true.
And people call me.
Son, he was a little boy.
Right. And I get calls about every topic you could ever imagine. And I'm very good at one, telling you I don't know anything about it, but let me see who is doing the work that could help you to understand. Because I'm not going to talk about something that I don't know. A lot of people call me about public benefits. My agency does not provide services regarding public benefits. So I'm not your person. But if you call me, I probably give you the individuals that do that work. So I will say this. We have, and I know it's difficult for the professionals here because you are juggling so many different pieces and you want to assist families but before we talk about something that we don't know enough about it, reach out to individuals that do the work. And like I said in the beginning, in terms of decision making, in terms of trust funds and all that, you can always call me and I'm going to give you the right information.
I do appreciate what you say.
Before you harass parents. I actually, the same parent that I keep talking today is fresh in my mind because she was so stressed about the agency asking her to become her child's guardian because her child was 29. And this person, according to the information that she provided me, doesn't need a guardian. True. So why the agency is telling her, get a guardian when this person doesn't need it? And once again, we are always working. I work on their program called the Disability Justice Program. One of the focus and goals is to support people with disabilities and to support their independence. So if you call me and you tell me my child, have this, that, and the other, and he could make decisions, but I want to be the guardian, guess what I'm going to say? I think you need to explore other things because it seems the guardianship is not appropriate.
Yeah. And so, also don't want Christopher to lose his DAC benefits because our kids are qualified to collect under the parent who is the highest wage earner. Mm-hmm. And then they get Medicare, Medicaid, but they go to work and make more money than dad or mom. They lose that coverage, and that is more scary to us. So I appreciate everything you said, and I thank you because I know what else I have to do, but thank you so much.
You're very welcome. Okay, do we have any other questions? People have other questions, concerns? No, yes? They're all quiet.
Doris, you're muted.
Hi, my name is Doris Khan, and perhaps you said this already, I apologize. But if someone does not designate a guardian and something does happen, what is the laws, then who would be in charge according to the law?
Okay,
if they did not approve it.
Okay, if someone doesn't have a guardian, First of all,
Right, it wasn't done. They didn't get to do it or something, right?
okay, but we are assuming that this person is by law an incapacitated person. That's number one.
Yes, yeah,
So
right.
we assume
The
we
person
are
is living at home and then the circumstance happened, something happened, suddenly they never did guardianship, they were living
Okay.
with parents. Yeah,
Okay.
I'm just curious
okay.
what
So
would happen.
so if something happens, a decision needs to be made. In terms of emergencies, doctors are gonna move forward because they have swear to save lives. So they're not gonna stop pumping somebody's hearts because they don't have a guardian and say, where is the paper? That's not gonna happen. But for example, and I get these calls too, I got a call from a grandmother who the granddaughter have severe disabilities and she needed extractions and they needed to put her to sleep because they couldn't do that without putting her to sleep. And the dentist is like, who is the guardian? Because this person doesn't have capacity. So that grandmother ended up doing surrogate decision-making requests. And the information is there. And after that, she quickly learned that she needed to be a guardian. So she started the guardianship process immediately. But those are the things how you solve those issues, surrogate decision making. That's why they're there. And that's all for medical. But now for those individuals who need guardians, there's somebody who is willing to do the process, then they have to start the process because it's paperwork. You don't need an attorney, you don't need to pay anyone, it's paperwork. So that's why I'm here talking about planning, because we cannot wait for emergencies to happen and then we panic. We need to start thinking about this when it's appropriate. Once again, now, it might be that with supported decision making, a lot of individuals fall into that category and they need to start that process. And that process takes also like 6 months. So I would suggest for providers, for families to start looking early on, what is it that the child needs and what is the tool that is going to serve them the best. The other part, and I'm glad that you asked me this question, is that I work with families all the time. And when I ask the family, do you know the level of capacity of your child? Oh, I don't know. So families need to have conversations with evaluators. I assure you, if your child is 18 or over, a lot of evaluations already happened. And we can just not take the copy of the paper and file it. We need to read it, we need to understand it, and we need to ask questions. So I also, all the time, and I don't know if you see my title, and also a special education coordinator for my office. So I get a lot of the kids when they're still little because they're issues with school. And from that time, the minute that I speak with that family, the first thing that I say is review the evaluations, ask questions so you understand what's going on with your child. So that way you start thinking about the future and what needs to be the plan for this individual. So I will suggest the same thing for the providers here. When you have people helping individuals to be eligible for OBWDD, for the eligibility, and there's 1,000 pieces of paper that you ask for, and also evaluations. Also ask the families to read those evaluations. Just don't go to the process like automatic, robotic. No, we need to learn. We need to understand. We need to, if you are in front of evaluator, that's the opportunity to have to ask those questions. So you start understanding, okay, my child is gonna need somebody to support them, whether through a guardianship, whether to support decision-making, whether it's a healthcare process, whatever that is, you need to learn early on. Thank you for the question. Anyone else?
Thank you. Thank you.
Dolores Khan, who has her hand up.
Go ahead.
I asked the question. She answered me.
Oh,
Thank you.
that was Doris. Doris just was, I was talking to her just now. Anyone else? Anyone else?
Paola, thank you. I just wanted to make more of a comment, not a question. And I know you mentioned that parents have to know what to ask the evaluator. I think sometimes a lot of times parents just don't know. They don't know what the questions to ask. So I think as providers, as we becoming more educated, and maybe the care managers sometimes that assist the parents, and a lot of time it started from the school system, right? So maybe the
Mhm.
school educator need to have that information, like a cheat sheet for parents, to know what questions to ask. They may not know what kind of questions to ask when they get with the evaluator that's going to help them, in order to get the services that they need.
That's a good point, and that's why I make my point that every time that I have the opportunity to work with families, I talk to them about this. I talk to them about evaluations, what that means, and for them to ask questions and understand what's going on. Because it really, really, for me, I'm always willing to help and assist. But sometimes if I see a child who's 17 years old, and you ask a parent, do you know what's your child's disability? Oh, I don't know. Do you know? I only know that he goes to school, and now the school he having issues. So that pains me, because in my mind, that means that this child is 17, is in 10, 11th grade. Probably a lot of things have been missed because the parent doesn't know that, what really the child needs in the school setting, and what is it that is going to happen when the child transition out to that setting. So I always, my conversations with parents always take long, because I try to inform them as much as I can. But also I understand that sometimes it could be very overwhelming for parents, because all these systems requires so much from the parents. Bring me this paper and that paper and this application and this appointment, and also mindful of that. So once again, one of the reasons that I do these workshops is to outreach to the professionals, so you can trickle down the information, and for the families to have access to information. And once again, I'm very good at dedicating time to the families, because that's my sole purpose: education and outreach to families, and and improved systems. So once again, you can feel free to give them my phone number, my email, and I'm more than happy to speak families for them to understand what's going on. Yesterday, this lady, once again, I'm sorry I keep mentioning her, I spent over an hour with her over the phone, because she has so many questions. And in order for me to almost undo all the amount of misinformation she have been provided, that was the hardest part for me, to undo what is being put on her head about what she needed to do. And it was the wrong information. So, I thank you, everyone who participated today, because that means that you're interested in the topic, and you're also interested in providing appropriate information to families. Anyone else out there?
Thank you.
Deborah will be the last one.
Unmute me. Help.
You're clicking too many times.
Then unmute me, please.
You're on mute now. We can hear
Can
you.
you hear me? Okay.
Yes.
Paul, is one thing I have forgot to add. A lot of families don't want to say what's really wrong, because they're ashamed, and also when the individuals here, they think they're bad. Because I used to be an advocate for someone, and the daughter was like getting upset with me. And I looked at the mother. I said, I'm not going to advocate for you anymore, because you don't want to understand. Our system doesn't want to know what your child can do. They want to know what they can't do to get the services. And you don't want to understand that. So then when your child has issues and we try to help you, you constantly give me a hard time. So I want the agencies, you have to explain that it's not what it look when the kids go to work, or then that's great. What can they do? But you also have to tell them what they can't do, or else they're not going to get any help or services. And that's why, like, a lot of times I advocated for my son and two others, and I helped them all get up. They were always in special ed, but they were able to make it through and get the help and services, because I said to him, there's things you can do and there's things you can't do. Because I said, not everyone can be a doctor, not everyone can fix a car. That they understood. But that's a big issue we have. Parents don't want to accept what's wrong with the child.
And thank you for bringing that up, because that's usually a lot of the clients that call me with special education issues. They want all the services, but they don't want, the classification, or they want the services the way they want it without an IEP. And I also understand that process. I think a lot of parents of kids with disabilities, sometimes they're not prepared to deal with the reality of what this means. And once again, when I deal with families who I understand there is a lot of denial or a little resistance to understand what's going on, what I often suggest is that support groups. I said, you don't have to get it from me. I just, I in order for me to do your work, I need to do the work, and to help your child, I need to understand what's going on. So you need to provide me with all this information. But for yourself, I think it will be helpful to join support groups, so that way you will understand everything that's going on. And of course, I mean, I cannot force anyone to go anywhere, but from that perspective, I am clear. I have families that, well, my child doesn't have an IEP, my child doesn't have a disability, the school wants to push them out, want to force things on them. And so it's part of that conversation as well that I have with them, that, you're only going to get those services through an IEP. If you want speech therapy, if you want occupational therapy, those services are only through an IEP. There is no other way, unless you're going to pay outside of the school and independent providers to do that without nobody knowing. But if you want the school to do that, they have to have an IEP. There is no other way around. So once again,
you're right. Yeah. And they forget one other important thing. If there is no proof of a disability before the age 22, they can't go under an OPWDD umbrella for services. And when it comes to Social Security, their child will not be able to collect, because they will not be considered an adult child survivor or a disabled adult child. And then they are entitled to collect under their parent's Social Security number. And in New York State,